Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, and I'm joined today by Maisie Greene, an associate here at Thomas Fisher and Edwards. Maisie, you joined me for a prior podcast where we introduced you since you're relatively new at the firm, and we also talked about how you are primarily working out of our Spartanburg office. But this will be the first time that you've joined the podcast for a substantive topic, and so I look forward to talking with you today.
Yeah, I'm really happy to be here and excited to get going.
Yeah, and so today's topic is going to be on trust funding. And so just to kind of set the tone for this, we've done prior topics that are very similar to this. I think the very first episode of this podcast, we did the 4 ways that assets pass at death, which are by beneficiary designation, which is outside of probate and applies to things like life insurance policies and brokerage accounts and retirement accounts. We also talked about survivorship, which is the way that property passes between joint owners outside of probate. We talked about property that passes through a will, which is through probate or through intestacy through probate. And then one of the 4 ways is through a trust. And so we're going to kind of hone in on that particular topic today and talk about, okay, well, if we set up a trust, partially for probate avoidance, then how do we actually fund that trust and put assets into it? And again, a lot of this goes back to probate avoidance, and I'll also remind folks on that topic as well. Since we talked about this in a prior episode, the things that we're trying to avoid with probate are the time delays, because it's a drawn-out process with court involvement, the privacy concerns, because probate is a public process, and also fees, because probate courts, at least in South Carolina, charge a fee for probating an estate. So that's a much longer intro than I typically give here on the podcast, but I did want to kind of level set for everyone so that you can now focus on our primary topic for today, which is trust funding. So in simple terms, Maisie, what is trust funding and why is it important?
Yeah, so trust funding is very important because you might come to an attorney like us, you create a trust, but people sometimes have the misconception of, oh, my attorney handled transferring all my assets to my trust. When I signed the document, everything went into the trust. And that is very much not true. A lot of times I tell my client, this is actually the time when you have homework, really, to fund your trust, properly get all the assets titled into it, or set up via beneficiary designation, because otherwise, to be honest, you wasted a lot of attorney fees setting up a trust. A lot of times you will have a will that pours everything into the trust. So if you do end up in probate, if you have all your assets, let's say you never funded the trust, they're all in your individual name, they will eventually get to the trust, but then we have to deal with all of the negatives that you just stated of why we want to avoid probate. And so then now we're in probate and it gets to the trust, but we've got the fee, we've got the expense, we've got the length, and we've got the lack of privacy.
That's right. And I think something you touched on there is there's really no magic ability for us as attorneys to just prepare the trust and snap our fingers and everything is done. It is homework, but it's doing the work now so that the client can actually handle that work rather than their heirs, their children, or someone having to handle the work after their lifetime, which is harder because they've got to gather all the information and they've got to go through those processes when the person, that ends up passing isn't here to help at that point in time.
I think that's a great point because sometimes I've had even clients now, we're on the other side of it, we're doing estate administration. We don't even have access to some of the passwords. We don't even know what accounts are out there. Right. Whereas if accounts are already titled in the trust, there's an acting trustee, they know what the accounts are. And a lot of times advisors, this is where your financial advisors or people are coming in and helping you, but it's much easier when the grantor of the trust is alive. You know what your assets are, or at least you have the best understanding of it. Your successor trustee or administrator is going to be lost and frankly overwhelmed. So it's much easier to do it now.
Yeah, and so from a technical standpoint, trust funding, today's topic is actually putting assets in the trust. But if the primary goal is probate avoidance, I touched on earlier, one of the ways that you can avoid probate is through beneficiary designations. So through those assets like retirement accounts, life insurance, bank accounts, and things like that, where you could just avoid probate or maybe name the trust as a beneficiary, what would you say the pros and cons are for actually titling those sorts of assets in the trust as compared to just listing the trust as a beneficiary of those assets, since either of those are ways to avoid probate?
Yeah, either of them work. I think one of the pros of putting it in the trust now is in the event that the grantor of the trust becomes incapacitated. We usually have a durable power of attorney. We've appointed someone to handle their financial matters as an agent. But if you have an asset titled in the name of the trust and you have a successor trustee that comes into place, even when that grantor is alive but incapacitated, that successor trustee has not more authority, but it's easier to prove to banks and financial institutions that they have the authority. Whereas if we're using an agent under a power of attorney, it's much more cumbersome. There's a lot more red tape to say with these financial institutions. So if it's already in the name of the trust, it's a little bit easier in the event of incapacity. Also, it's easier in administration. It's already in the trust. So when the person dies, it's already in the trust. Versus a beneficiary designation, we're then working with the banks and everyone to send it out to the trust via the beneficiary designation. So it doesn't totally matter. Both work great, but trust is usually the gold standard, namely in the name of the trust. But again, we'll get into this later, but depending on what kind of asset it is, we don't want a title in the name of the trust. Right. So it kind of depends on what the asset is. And also working with your advisor, sometimes an advisor will say, it's actually just easier to put it as a beneficiary, because if we are going to put it into the name of the trust, they often have to open a new account. You have to get a new account number. So sometimes it's more cumbersome, and the advisor will say, it's actually easier on our end to just put it as a beneficiary, and that works too.
Yeah, and that's certainly something I like to do, is work along with the client's financial advisor and see what works for you. Either works for us from just a pure probate avoidance standpoint, and sometimes they'll have strong opinions one way or another. Beneficiary designations certainly are easy and simple, and so that can be great. But you made a great point about the incapacity planning and how actually having assets in the trust can be helpful. So we've talked in kind of generalities. Let's focus on a few specific assets and how we go about trust funding, either through beneficiary designations or actually changing title. So when it comes to checking accounts and brokerage accounts, you've really just touched on this, but do you want to reiterate how you would go about handling those types of assets?
Yeah, so they're different. Checking accounts, I usually tell my clients, name your trust as the beneficiary, because your checking account is your most trafficked account. You've got automatic pay set up, you've got checks already made for that account. That money's coming in, money's coming out quickly and easily, and you don't want to have to change the title, update all the auto pay, get new checks and all that. So make the beneficiary the trust. It's easier. And then for brokerage accounts, I do suggest to my clients titling those in the name of the trust. Of course, there might be situations where, like we said, a financial advisor says it might be easier to just do the beneficiary of the trust. When we're talking about married couples, usually they have a joint brokerage account. If we're doing planning where we are setting up a spousal trust for the surviving spouse to lock in those assets to go down to their mutual kids, is usually the typical thing we're planning for, then I often suggest splitting up those brokerage accounts, and half of it is owned in the name of the trustee of the wife's trust, and half of it's owned in the name of the trustee of the husband's trust. Right. So then it flows down and we 50-50. So sometimes we have conversations with clients too about, let's try to balance assets between the two trusts so that we've got half locked in for the surviving spouse, and then the other half is for the, we've got the locked in trust, and then we've got the revocable trust for a surviving spouse. Yeah,
that's a really good point as well. If you are planning for that sort of spousal trust, if all the assets just go to the joint owner, then they don't make their way to the trust. And I do have clients who sometimes are, if they've had their finances together, they're not super happy about the idea of dividing up their brokerage accounts, but often from a practical sense, it ends up not being a big deal because they can divide it up and they can go to their financial advisor and tell them, hey, still invest these assets the same, still treat it as though it's one account. And often financial advisors have an ability to sort of do that in a way so that it doesn't really feel like they're dividing their assets up. It's really just something that's on paper. Yeah. And so let's talk about real property. How do you typically advise a client who has a trust to title their real property? And you're licensed in a few different states. Does what state they're in have any impact on that?
Yeah, I was actually just talking to clients about this morning. So if you're a married couple in South Carolina, I typically advise you to own the house as joint tenants with right of survivorship. So both of you own it in your individual name. And then when the first spouse passes away, it automatically goes to the survivor. But then I'm telling my clients, remember that surviving spouse has to remember to put it into their trust.
Right.
Now, we're also dealing with the situation of there's a risk you die at the same time, and then we're in probate. So there can be risk. There's also a risk the surviving spouse is incapacitated and struggles to get that house into their trust at that point. So sometimes it's better to put the house as in 50-50 in each of the spouses' trusts as tenants in common. That can work. Or we're doing it just in their individual names, joint tenants with right of survivorship. Now, in North Carolina, you asked about other states, they have what's called tenancy by the entirety, which we do not have in South Carolina. And that provides greater creditor protection for those spouses. So if one spouse is sued and they own an asset as tenants by the entirety, the creditors, for the most part, can't get to those joint assets that are owned in that way. So we advise our clients in North Carolina, keep that house as tenants by the entirety. And then when the surviving spouse survives and the first one dies, put it into your trust at that point.
Yeah, certainly, because you're kind of weighing the probate risk of if we die at the same time, then we may be subject to probate. But when you add in that factor of North Carolina and the great creditor protection that you get for tenancy by the entirety, where the asset is protected from the creditors of just one spouse as opposed to their joint creditors, that can be, in my opinion, enough weight on the scale to say, let's leave that as tenants by the entirety. We'll take the small risk of probate if you die at the same time.
Right.
But we really like that creditor protection. So that's a really good point about how that can kind of tweak that analysis.
One thing I'll add, I forgot to mention, if you are going to, you can also own a house just in one person's trust. So sometimes when we're trying to do that balance between spouses, we'll just put it in one person's trust.
Sure.
And then if you do that, you need to reapply in South Carolina for that reduced 4% property tax rate instead of the 6%. It still will work if you own it in your trust. You just have to often reapply to make sure you get that 4%.
Yep, that's a very good point as well. And so how about automobiles and other personal property? What do you typically advise on those sorts of assets?
Yeah, so vehicles, pretty much gold standard. The primary driver of the vehicle should be the sole owner of that car. I often see clients where they've got both of their names on the title. For liability purposes, again, if you're in a car accident and both of your names are on the title, but only one person was driving, you'd rather just one person get sued instead of both of you. It's not foolproof, but it gives you a little bit more protection. So primary driver should own the vehicle. And then as of this summer 2025, a new law in South Carolina was passed so that you can name a beneficiary, transfer on death beneficiary, on the title of your vehicle. So we're voting probate for a $4,000 vehicle or something. So that's a great benefit. Now, North Carolina doesn't have that yet. It's a little bit harder in North Carolina. So usually still primary driver vehicle in North Carolina. For other personal property, when we prepare trusts, we prepare assignments of tangible personal property. So all of your untitled assets, think about like jewelry, furniture, anything without legal title, it's going to go into your trust. We've already handled that at the signing. So maybe some people have the misconception that handled all my assets. No, it just handled your tangible personal property.
Yeah, the ones that don't have some sort of separate title, legal title. Mm-hmm. And another thing that I'll note on the automobile issue is that we typically don't put those in trust during lifetime just because it can lead to issues with insurance. Often insurance companies will charge a higher rate if the assets are in trust. And then we don't really litigate, but we've been told by some of our litigator friends that if you have your automobile in a trust and then get sued based on something that happened with it, it often can be a sign to a plaintiff that, this person may have money, even though that's not necessarily true just because they have a trust, but it can be an indicator of that, and then they perhaps can come after you harder or something like that. Yeah. And so those are maybe reasons to not put the automobile in your trust. Mm-hmm. Ideally, we would be able to use those beneficiary designations to appoint to the trust upon death. But as of yet, the South Carolina Department of Revenue is not allowing for that, even though I think theoretically it should be allowed based on the way the law is drafted.
Correct.
But the ability to name an individual as a beneficiary is a good way to keep the asset titled in your name, but also make sure that it avoids probate as long as you have a good beneficiary to name.
Yeah, and again, people need to remember if that beneficiary you've named has passed away, you need to go to the DMV and update that beneficiary.
Sure.
Yeah.
And so we, of course, do a lot of business law as well. We represent a lot of closely held business owners with respect to their estate planning, but also with respect to their businesses. How would we typically advise that they title their businesses, whether that be a corporation or LLC or other entity?
Yeah, business interests should be owned in their trust. There's many reasons for this, but one of the main one is probate is public. So if it's in your individual name, it's going to pass through probate. We have to get a valuation. We're now valuing the business, which we don't want to be public. And they know, the probate court knows all about these businesses, and they're getting a fee.
Right.
So we want to put it into the name of your trust. We can do that via an assignment of membership interest for an LLC, or we're signing over, new stock certificates. And you and I and a lot of our attorneys do a really good job of, we review the buy-sell agreements, we review the operating agreements, we review any stock restriction agreements, and we make sure, do we have the authority to do this before we do it? And oftentimes we see some things we might need to clean up in the corporate documents anyways, so we're help clients with that. But yes, 100%, for the most part, business interests should be in your trust.
Yeah. I agree, and you made a good point there on making sure that you check those restrictions on transfer in the governing documents to make sure that we're not accidentally triggering a buy-sell or something like that. Most well-drafted operating agreements or bylaws or things of that nature, shareholder agreements, will allow for transfers to a revocable trust of the type that we're discussing here, but sometimes they don't, so it's always good to check that. And then finally, you mentioned earlier that some accounts are restricted in some ways. So life insurance and retirement accounts have beneficiary designations just like brokerage accounts, and so in some ways you can certainly just use those beneficiary designations. What is special about life insurance and retirement accounts as compared to those other assets that have beneficiary designations?
So those, you're not going to change the owner. That's not an option for you for life insurance or retirement. So life insurance, you're going to keep the owner as whoever the owner might be, and then the beneficiary is going to be your trust. And then for retirement accounts, same thing there. You absolutely don't want to change the owner. You'll have all the tax issues that come with that. So you want to keep the owner as it is, and then the beneficiary will be the trust. Now, you do want to talk with your attorney and make sure that the trust is structured in the appropriate way to receive those retirement benefits in a tax-effective way, in the way that you want to, which the way our trusts are structured, they can handle that. But it's often a discussion with clients.
Yeah, and so I think that touches on the majority of the assets that we typically talk through with our clients. We, of course, ask them if they have other sorts of assets that we're not thinking of. But just in general, when it comes to trust funding, what are the common mistakes that you see clients make?
I think neglect is the first one. Clients will come in and say, well, we handled all of that, and they haven't yet, and they just weren't properly educated on what that means. Or maybe they've got beneficiary designations to their kids, but their trust says that those assets should actually pass in a different way. So the beneficiary designation will control, and the trust terms are not going to. So sometimes there's a mismatch between the trust and the beneficiary designation.
Yeah, I agree. Even when they try to do things right, they have that beneficiary designation that says it goes to my kids, but really we wanted it to go to the trust for the kids' benefit, so that they're getting certain protections, and we want to make sure that all of that aligns and that it's consistent with the overall plan.
Yep.
You mentioned earlier the issue with transferring real property to the trust and making sure that you reapply in South Carolina for the special assessment ratio for a primary home. What other sorts of things should be coordinated when an asset is transferred to a trust?
Yep, so you should let your homeowner's insurance know, car insurance, if you're transferring a vehicle or something, property insurance, anything like that. Your insurers need to know when you're transferring.
Yeah, absolutely. You want to make sure that actual ownership matches any of those insurance policies and things of that nature.
Yep.
And then when you make those transfers to trust, does anything change for tax purposes?
Nope, there's no income tax difference. The revocable trusts are grantor trusts. They're taxed based on your social security number. So no reality of your life changes.
Yep.
Now, when you die, those trusts will get their own tax ID number. They'll file a 1041. They have their own income tax return, but nothing while you're alive.
Yeah, and I'll reiterate again for our listeners that what we're talking about today with respect to this is just a revocable trust that you do as part of just sort of standard estate planning for probate avoidance. We're not talking about irrevocable trust that we're doing for estate tax purposes or anything like that. That's a completely different animal, but this is something that we're just talking about when you meet with us and we're talking about your will and your revocable trust and we're trying to avoid probate. Those sorts of trusts, it's just an extension of the client. It's as if they continue to own the asset for tax purposes.
Yep.
And so, Maisie, this has been a great overview of all of these topics. We like to give practical insight for our listeners. And so what would you say is the most important step for someone to take if they have a trust, but they're unsure about whether they've actually funded that trust or have everything set up right to carry out their trust plan?
Yeah, I mean, I think every year at least you should be taking an inventory essentially of your assets and looking at who's the owner, who's the beneficiary. If your attorney gave you a trust funding letter or anything like that, look back at that letter and see what were their instructions. Do I need to reach back out to them and ask them the best way to handle this? This is also where financial advisors and financial planners are a huge help. You reach out to advisors that will help you get a sense of these are my assets. This is who owns it, and this is how it's flowing out, and work with both the advisor and attorney, and they'll be the best people to help you kind of get a sense of everything.
Yeah, I agree, and that's something that I always encourage my clients as well. They don't like reaching out to us as much because we're typically charging by the hour, but it can be great if you're really worried about it to introduce your financial advisor to your attorney, ask them to coordinate with one another and talk through, make sure that they're on the same page with everything. And if you also have like a closely held business or a more complicated overall situation, introduce your accountant to them as well and let everyone put their heads together. Also, your insurance advisor, if you have a separate insurance advisor, let everyone put their heads together and make sure, do the title of the assets match the estate plan? Does that match what's being reported for tax purposes? Does that match what the insurance policies say as well?
Yeah.
But, all of those, we don't try to do everything. We try to play our role, but let all of those professionals that you work with work together so that they can best serve you.
Yeah, I agree.
Okay. Well, thanks for joining me again today, Maisie, and I look forward to having you on future podcasts as well. I've mentioned this in some of our other podcasts, but if we have any listeners that are interested in any particular topics that you would like us to go into more detail on, or just completely different topics that you would like us to discuss, feel free to drop a comment into whatever listening platform you're listening to us on, and we will certainly try to cover those topics. And we'll see you next time on TFE Talks.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.